Erin Brockovich and the Real Story: Environmental Crimes and Corporate Cover-Ups. This is the true story behind one of the most famous environmental lawsuits in American history. It is a story of contaminated water in Hinkley, California, of Pacific Gas and Electric Company, and of how one legal clerk helped expose a corporate failure that reshaped environmental litigation in the United States. In 1993, in the small desert town of Hinkley, California, a legal clerk named Erin Brockovich began asking questions that would expose one of the most significant environmental contamination cases in American history. The company at the center of it all was Pacific Gas and Electric Company, better known as PG&E. The contaminant was hexavalent chromium, a toxic chemical compound used in industrial cooling systems. The allegations were simple but devastating. PG&E had allowed contaminated wastewater to seep into groundwater, and residents were getting sick. Erin Brockovich was not a lawyer. She worked for attorney Ed Masry at the firm Masry & Vitito in Thousand Oaks, California. What she did have was persistence. While reviewing real estate documents related to a client's property dispute, she noticed medical records attached to the file. The property in question sat near a PG&E compressor station in Hinkley. That anomaly raised suspicion. Why would medical records be attached to a routine land case? The answer began to emerge when Brockovich started visiting residents door to door. Families described clusters of illnesses: cancers, miscarriages, chronic nosebleeds, respiratory issues, and skin conditions. Many residents said PG&E representatives had assured them that chromium in the water was safe. The compound involved was chromium-6, or hexavalent chromium, which the Environmental Protection Agency had long recognized as a toxic substance. The chemical was added to cooling tower water to prevent rust. Instead of properly disposing of the wastewater, the company discharged it into unlined ponds. From there, it leached into the groundwater. By the mid-1990s, a plume of contaminated groundwater stretched for miles beneath Hinkley. The California Regional Water Quality Control Board had begun investigating PG&E's site in the 1980s. In 1987, PG&E agreed to a cleanup order, but residents said they had never been told about the full risks. Erin Brockovich and Ed Masry built a case representing more than 600 plaintiffs. In 1996, PG&E agreed to a settlement of $333 million. It did not require PG&E to admit wrongdoing. The chemical at the center of the case, hexavalent chromium, had already been the subject of federal scrutiny. The Occupational Safety and Health Administration, OSHA, classifies hexavalent chromium as a carcinogen. The Environmental Protection Agency lists it under hazardous substances regulated by the Clean Water Act and the Safe Drinking Water Act. The Agency for Toxic Substances and Disease Registry, part of the U.S. Department of Health and Human Services, has published toxicological profiles documenting links between chromium-6 exposure and lung cancer. The Erin Brockovich story did not end in 1996. In 2000, the film Erin Brockovich, directed by Steven Soderbergh and starring Julia Roberts, brought global attention to the case. But long after the Hollywood portrayal, the environmental consequences remained. PG&E continued remediation efforts in Hinkley under oversight from the California State Water Resources Control Board. California briefly adopted a specific maximum contaminant level for hexavalent chromium in drinking water in 2014. The standard was set at 10 parts per billion. However, in 2017, a California Superior Court judge in Sacramento ruled that the standard had been improperly established due to economic feasibility calculations, leading the State Water Resources Control Board to withdraw it. As of subsequent regulatory updates, hexavalent chromium remains regulated under total chromium standards at the federal level. The Hinkley case fits into a broader pattern of environmental crimes and corporate cover-ups in American history. Consider Love Canal in Niagara Falls, New York. In the late 1970s, residents discovered that their neighborhood had been built on a toxic waste dump previously owned by Hooker Chemical Company, later acquired by Occidental Petroleum. Journalists at the Niagara Gazette, including Michael Brown, reported extensively on birth defects and illnesses. President Jimmy Carter declared a federal emergency in 1978, leading to the creation of the Comprehensive Environmental Response, Compensation and Liability Act of 1980, commonly known as Superfund. The case Tennant v. DuPont uncovered internal company documents showing DuPont had known about potential health risks associated with PFOA exposure for decades. Investigative reporting by the Washington Post and the New York Times detailed how the chemical had contaminated drinking water supplies along the Ohio River. In 2017, DuPont and Chemours agreed to a $671 million settlement to resolve thousands of personal injury claims related to PFOA exposure. The Environmental Protection Agency has since issued health advisories for PFAS chemicals, including PFOA and PFOS, under the Safe Drinking Water Act. The Michigan Department of Environmental Quality failed to apply corrosion control treatment. Lead leached from aging pipes into drinking water. Residents complained of brown water and rashes. The crisis led to criminal charges against several state officials and a $626 million settlement announced in 2020. These cases share common themes: regulatory oversight gaps, corporate denial, and communities forced to fight for recognition. Environmental crime can include illegal dumping, falsification of monitoring data, and failure to report hazardous releases. The U.S. Department of Justice's Environment and Natural Resources Division prosecutes such cases. In United States v. BP Exploration and Production, Inc., following the 2010 Deepwater Horizon oil spill in the Gulf of Mexico, BP agreed in 2012 to plead guilty to 11 felony counts of manslaughter and to pay more than $4 billion in penalties. In Hinkley, the legal battle demonstrated how civil litigation can complement regulatory action. Erin Brockovich did not rely solely on environmental statutes. The lawsuit invoked common law claims including negligence and nuisance. By gathering medical records, water test results, and sworn statements, the plaintiffs built a narrative grounded in evidence. The Hinkley case also raised questions about corporate communication. Court filings indicated that PG&E had sent pamphlets to residents describing chromium as safe. Yet hexavalent chromium differs significantly from trivalent chromium, an essential nutrient in trace amounts. The distinction matters. Scientific studies published in journals such as Environmental Health Perspectives have documented carcinogenic effects associated with inhalation of hexavalent chromium compounds. Corporate cover-ups often involve internal documents. In the DuPont case, memoranda dating back to the 1980s showed awareness of PFOA's persistence in human blood. In the tobacco litigation of the 1990s, companies such as Philip Morris and R.J. Reynolds faced evidence that executives had long understood the addictive properties of nicotine. The 1998 Master Settlement Agreement between major tobacco companies and 46 U.S. states resulted in payments exceeding $200 billion over time. Transparency laws like the Freedom of Information Act have played a crucial role in exposing environmental hazards. Journalists and activists use FOIA requests to obtain internal correspondence from agencies such as the Environmental Protection Agency. Public records requests in Michigan helped reveal communications during the Flint crisis. Erin Brockovich has continued her advocacy work beyond Hinkley. She has spoken publicly about other contamination cases, including groundwater issues in Midland, Texas, and in communities affected by coal ash disposal. Coal ash, a byproduct of coal-fired power plants, contains arsenic, mercury, and lead. The EPA's Coal Combustion Residuals Rule, finalized in 2015, set national standards for disposal. Environmental justice has become a central theme in these discussions. The concept, recognized by the Environmental Protection Agency, addresses disproportionate environmental burdens borne by low-income communities and communities of color. In 1994, President Bill Clinton signed Executive Order 12898, directing federal agencies to consider environmental justice in decision-making. The Hinkley residents were not a wealthy constituency. Many relied on well water. They lacked the political clout of major corporations. Their case underscores the asymmetry between multinational utilities and rural households. PG&E itself has faced multiple legal crises. In 2019, the company filed for Chapter 11 bankruptcy protection in the U.S. Bankruptcy Court for the Northern District of California following catastrophic wildfires, including the 2018 Camp Fire in Butte County. Investigations by the California Department of Forestry and Fire Protection, CAL FIRE, determined that PG&E transmission lines ignited the blaze. In 2020, PG&E pleaded guilty to 84 counts of involuntary manslaughter related to the Camp Fire. The recurrence of corporate misconduct raises questions about deterrence. Civil settlements may compensate victims, but they do not always transform corporate culture. Criminal liability, regulatory fines, and public scrutiny form a triad of accountability. Environmental law intersects with public health, tort law, administrative law, and criminal law. Agencies such as the Environmental Protection Agency set standards. State bodies like the California State Water Resources Control Board implement them. Courts adjudicate disputes. Investigative journalists provide oversight. Citizens demand answers. The story of Erin Brockovich and Hinkley illustrates that legal change often begins with ordinary individuals scrutinizing paperwork and asking uncomfortable questions. It shows how public records, scientific evidence, and community testimony converge in courtrooms. Environmental contamination does not respect property lines. Groundwater flows beneath fences and highways. Airborne pollutants drift across state borders. The National Ambient Air Quality Standards, established under the Clean Air Act, attempt to control such transboundary risks. Yet compliance relies on monitoring and enforcement. When corporations conceal hazards, the damage extends beyond physical illness. Trust erodes. Democratic accountability weakens. Restoring that trust requires transparency and rigorous enforcement. In Hinkley, remediation continues decades after the original settlement. Monitoring wells track chromium concentrations. Reports are filed with regulators. The legal case may have closed, but the environmental story remains active. Erin Brockovich's work reminds us that environmental crimes often hide in plain sight, buried in technical reports and regulatory filings. Exposing them requires persistence, legal strategy, and a willingness to confront powerful institutions. The Hinkley case stands alongside Love Canal, the DuPont PFOA litigation, the Flint water crisis, and the Deepwater Horizon disaster, as a chapter in the ongoing struggle to align corporate conduct with public health and environmental protection. The real story is not only about one woman or one lawsuit. It is about how laws like the Clean Water Act, the Safe Drinking Water Act, and the Superfund statute function in practice. It is about the role of the courts in balancing economic interests against human safety. It is about the communities that refuse to accept official reassurances when their water tastes metallic or their children fall ill. Environmental crimes and corporate cover-ups rarely begin with dramatic headlines. They begin with small discrepancies, unexplained illnesses, and documents that do not quite add up. In Hinkley, those discrepancies led to a landmark settlement and a global conversation about accountability. The legacy of that case continues to shape environmental litigation and regulatory policy across the United States.